So we're talking about immovable property and its relation to parties in respect of a divorce. Hi everyone, I'm Aisha Kareem, your family law specialist. Let's get into it. So one of the questions that I received yesterday was, what happens when the property is already in a family trust? Because in my previous video, I spoke about one of the solutions to the matrimonial home or the family home is that parties can transfer this property into a trust and perhaps make their children beneficiaries of that trust, and then they can have some sort of an agreement in place regarding who lives in the home and until when, until death, remarriage, until the youngest child finishes university. There's a whole bunch of things that are available to you. But what happens when you guys have already put the family home, the matrimonial property, into a trust and now you are divorcing? So the answer to this question depends on what exactly the trust says. So according to the trust, who are the trustees? If the trustees are the husband and wife, for example, and the children are the beneficiaries, for me, I don't see why that needs to change. You guys will remain co-holders of full parental rights and responsibilities over your children, even post-divorce. You will remain the parents of that child even after you are divorced. So I see nothing wrong in parents or partners remaining co-trustees, especially when their children are beneficiaries to that trust. Now, I think sometimes the complications come in is when the wife is a named beneficiary on that trust. Now, guys, just to let you know, if there is named beneficiaries on any trusts, those beneficiaries cannot be removed without their consent. So if you've said, my wife, Samiha Vauda, is a beneficiary to the trust, upon divorce, you cannot just remove her name from the trust. That would not be possible. Of course, by consent, she could say, I'm not interested, and she can have herself removed. But you cannot unilaterally remove a named beneficiary from a trust. So those are some of the complications that come into play if properties are already in a trust. Now remember, a trust, and I don't want to get too complicated because there is case law that allows us some moving space, but ordinarily a trust is seen as a separate legal entity. So you have your divorce and you have assets that are on the parties' names, and then you might have a trust or a business, a CC, a PTY Limited, which maybe the parties were both directors of, or like I said, in terms of a trust, they were both trustees of. Those are separate legal entities, and although, yes, they somewhat do impact the divorce and the divorce proceedings and the shares and the estate in and of itself, those are legally seen as separate legal entities. And so they would need to be dealt with in and of themselves.